Given this is the last webinar of the series, on behalf of CCA, I take this opportunity to sincerely thank our volunteers for their dedication and countless hours to organize this popular series. Thank you, Amber Sandu, Katie Fairley, Glenn Ackley, Kesa Banfai, Frank Feta, and Trevor Ostipew. Thank you again for your tireless efforts and for sharing your expertise. Sincere thanks also to Patricia Gujan from CCA for behind the scenes coordination and for helping with the tech support. On that note, since we have a lot to cover, I'll hand it over to our session moderator today, to Katie. Katie, over to you.
Hi, Kenny. Thank you. And thank you for your help over the last year almost as our task force has met to develop this webinar series. So again, my name is Katie Fairley with Fairley Strategies out of Vancouver. I'm the moderator today with our expert panel. We have Rick Wagner. He's the president of Maxwell Floors, also out of Vancouver. We have Heather Ostipew with Graham Construction out of Edmonton, and Glenn Ackerley with Weir Folds out of Toronto. So let's jump right into it. Rick, I think especially for trade contractors down that, kind of down the supply chain, down the payment chain, what are some of the first steps that you take when looking at, how are you going to get paid on a project?
Great question, Katie. Well, one of the big things here that, we can see a number of the different project delivery methods. And as a trade contractor, we're very eager to just get our quote together, get our estimating numbers and put something in and thinking, okay, that's my number. But before we get to that, we need to really step back a bit and create some form of a bullet point checklist on what is important to your company and you. All of these contracts that we see on the screen here have supplemental general conditions. You can reply with your terms for discussion if you're receiving a tender or a quote document from a general contractor. If you have a question, you need to overcome many of these problematic provisions within the supplemental conditions early. So the majority of companies are smaller than 10 people. So they always think, oh, I don't have the ability. Well, you need to take the ability to read what you're bidding, quoting, pricing, because the general contractors know the different contracts that they're sending out. So take the time, reach out to the estimator that's sending you the document, ask them, what is the project delivery method that we see on the screen here? And how does it affect you? What is the contract type? Is there a prime contract? For your own contract and also for a supplier's contract. So one of the easiest things I say is ask your providers, your surety insurance company broker. You can send them a copy of the contract on the insurance part if you're not understanding it. You got your banker if it's cash flow, especially if it's a project longer than a year. Maybe reach out to your lawyer or one of the professionals. Other things on contract types, and I don't want to go too deep here. Is there a bond? Do I need to get a bond and I have to start early? Or is there subcontractor default insurance? What is your risk in this project? So when you're bonding, we're talking about bonding with material and labor bonds, performance bonds. And I think I'll leave this for a little later, but you got to also be sure to understand what are the change and amendment provisions of the contracts, and following the required processes under those provisions prior to undertaking work outside of the contract. So one, it's the contract type, understanding it, and two, if you do get it, what are the next steps? So I'll stop there. I don't want to get too deep here, Katie. So hopefully that's a good start.
No, that's great. And I think that's underlining the whole series of these webinars, which is, read your contract, understand your contract, reach out to experts. We can't say it enough, but also, understand how that contract type it ties into your project delivery method. So that's great. Now, Glenn, I'm wondering if you could talk through, and we have them up on the screen here, kind of the different types of payment. It's not just one straightforward path to being paid and the types of payment. What should folks be looking for when they're reading their contract?
Well, this is, thanks, Katie. This really follows on from what Rick was saying. Those different project models that we looked at, types of contract delivery and project delivery models, often take different approaches to how payment is done, how it's handled. And even some of those models we had will change the payment method part way along the project, depending what stage it's at. Pre-construction, for example, pre-construction services may be paid for in a way that's different from the way the balance of the construction project itself is paid. So it is, I'll just reiterate what Rick said, it's so important to read the contract and the project delivery model first, to see how the payment terms are set out. And this list sets out different options. So the first one really is the one that is probably the most common one we're all familiar with, where you have a fixed or a lump sum or stipulated price. I'm going to do the project. I've agreed to do the project as a contractor for a fixed amount of money. You know, $15 million project, that's the amount. Well, how do you get paid for such a project? Every payment, and this is what the contract will say, every payment is really a payment in advance of what that total amount is. And how frequent it is will depend on what the contract says. But typically in that scenario, it's monthly. The important thing is you don't send bills for what it's cost you, of course. You send bills based on the progress that you've achieved in that month. And that's all set out in or structured around a schedule of values. And the CCDC family of contracts speaks to that, particularly the fixed price ones we're talking about here. There's a schedule of values that gets set and agreed upon at the beginning of the project for all the components of the project. And then as that work progresses, as the electrical work goes ahead or the foundation work and so on, all the line items in that schedule of values progress, whatever percentage complete was performed in the preceding month is what ends up being billed to the owner and gets paid for. Sometimes, and this is something I think would be on Rick's checklist, is to check whether, if you're a subcontractor, there's a disconnect between how you get paid and how the general contractor might be getting paid under the form of contract they've signed up for. Sometimes it's not identical. So just because the owner is paying the contractor maybe on a progress basis, your terms may be on a different basis, time and material, for example. But the idea of the first one, and is important, is that it requires an assessment or evaluation each month, how much of the work has progressed. And as you get near the end, it's how much of the work is left to do may determine how much you get paid. If there's concern on the payment certifier's part, of the consultant who's looking at the payment application, that there's not enough money left to finish the job properly, they might start to hit the brakes and slow down the amount being paid, because it may have been that you got, in their view, overpaid considering the amount of work. So it's done on an assessment basis month after month based on progress. The second one is much more mechanical in the sense that you apply for what it's cost based on hourly rates, perhaps the amount of time spent, and the material costs that were installed during the previous month. So a T&M, and there's a wide variety of these types, but that a T&M based contract, there are contracts like the CCDC 5B that we saw on the list, or the cost plus form of contract CCDC 3, that is a cost reimbursable contract, where it's the cost of the work plus some additional markup fee. So that's more actual monthly costs, both in time and materials. There are other variations to that. For example, quantity-based payments. We didn't put that specifically on the list, but that's another form of reimbursement, that as you do progress of moving materials, you're paid on a unit basis. That's another option. So you have to be clear the method of payment. Milestones are becoming more common, where you get paid, for example, when the structure hits the roof level, or the building's enclosed, or earlier when the foundation is finished and you're up to grade. And once you hit that point, that's when the owner writes a check. So that's another milestone payment, or another way of payment is through milestones. And then the frequency you have to look at, is it monthly? As I said, it could be more frequent, could be weekly. Or you may have a disconnect where the owner is paying the general monthly, but the general is obliged to pay a supplier, for example, weekly every time there's a supply. So you have to see how frequent it is. And then finally, there are models where the profit, for example, under integrated project delivery and other collaborative models, where the profit is set aside and is only released at the end if it's available and hasn't been otherwise spent. So look for those kind of things. And then finally, the timing of holdback release. Is it after substantial performance or substantial completion? Does it get released, or at the end of the job? Look for that as well.
Great. And Trevor, anything to add there?
Just one quick item. I wanted to underscore, Glenn brought up a good point around payment right at the end of the project. There can be a whole bunch of very unique nuances depending on the contract. I've seen some specific payments broken out for O&M manuals, or specific payments broken out for as-builts, or the value of deficiencies left over gets doubled, and that doesn't get paid until. So just watch for right at that tail end. You know, that last 5% can get very tricky with those last final payments, depending how it's structured.
Katie, if I just can add to what Trevor said, he's absolutely right. We had holdback release and holdback retention, but those holdbacks may not be just the holdbacks required by the statute in the province. There could be deficiency holdbacks or retentions. There could be maintenance retentions where certain amounts held back for the next year as a warranty holdback, as Trevor said. Those are the kinds of things you also have to pay attention to as you're reviewing the contract at the outset, because it affects your cash flow, of course.
Great. So as we kind of move along, Trevor, walk us through what other items could be there that is going to be affecting the payment flow, particularly around, let's say, with materials.
Yeah, so other things to look for in your contract for material payment terms. CCDC standard is payment upon delivery to site. However, supplementary conditions will often modify it. I'm seeing more and more payment on permanent installation, which can be a big time gap from delivery to site. And especially post-pandemic with some of these long lead time supply chain issues we're seeing, you may want to look at negotiating payment upon deposit or payment upon order place, because that can cause a significant cash flow strain on the contractor. The other thing to check is payment timelines. Again, the CCDC standard is upon receipt of invoice from the contractor, which is typically the last day of the month. The consultant will have 10 days to review and certify, and the owner has 28 days to pay. So that keeps them on that 1 month payment cycle post invoice. But again, look at the supplementary conditions closely. I've seen everything from, the owner has 30 days to amend and approve the invoice, and then another 30 days to pay. And then right there, you're looking at 60+ day payment terms, which can significantly throw off sort of the industry standard and industry expectation around that. Also worth considering or establishing amongst the project team is a process for dealing with invoice rejection or cutbacks, because the contract is often silent on that. But that's a place where timely payment can often fall off the rails. So, a consultant responding in 10 days, but they're responding with a rejection or a cutback. Well, then the contractors go back and revise and resubmit their invoice, or maybe they don't agree with all the cutbacks, and then they have to have follow-up meetings or phone calls to justify it. So then they revise and resubmit the invoice. The consultant has another week to review and approve, and the owner still needs their 2 weeks to process payment. So your 20-day window is gone. So just, it's good early on, you're in the honeymoon stage at the kickoff, establish the protocol amongst the team and have that process in place on how you're going to deal with any progress invoice adjustments.
If I could just add something,
I really like
Katie. Oh, I'm sorry.
Absolutely.
Go ahead.
No, I was going to say, I liked Trevor's point, and I think Rick also alluded to it as well, is around negotiating these terms. Once you've read your contract, don't be afraid to ask. Don't be afraid to, make your case of why, a clause may need to be amended. Sorry, Glenn, go ahead.
Well, a good example of what you just said, I think, Katie, is if it turns out to overcome supply chain challenges, you sit down, or the parties sit down and realize we need to order certain materials and get them in hand because there's a shortage, for example. That leads to a bunch of other questions, and Trevor touched on it. Where are they going to be stored? And what storage costs are going to be incurred, and who's going to pay for those? And I've seen situations where in the middle of the contract, the parties are fighting over who bears the cost, and it affects payment, right? Who bears the cost of storage, for example, and the owner wants to cut back the contractor who's billing the storage fees, saying, no, that was on you. So getting clear even on those things like the storage of materials that are ordered to secure them for the project, those are costs that have to be taken into account as part of this topic of payment. So read your contract, see what provisions there are about advanced ordering and handling of materials. We talked in the insurance session about whose risk those might be at, but the payment of them and then the payment of storage of them are all things to take into account.
And I think to underline the point, again, we've said it a couple of times, is that there's a disconnect between the prime and the subcontract. So, it's a subcontractor requesting, getting, and reading that prime contract when there's a flow down provision. So probably also can't say that enough for the subcontractors on the call. So on the topic of applications for payment and invoicing, Trevor, you talked about how now, like there may be, as you look to submit that compliance or that proper invoice, that in itself could lead to a delay. But what should folks be looking for to make sure that they're submitting that proper or compliant invoice or progress payment?
Yeah, so you're going to want to read your contract and double check what sort of supporting documentation needs to go alongside each progress claim. Like, what do we need to provide for invoice backup? Is it LEMs, time cards, invoices, receipts, etc.? And then what do you need for complementary documents? Do we need to include an updated schedule, progress report, site photos, cash flow curve, or the dreaded narrative that every contractor hates putting together? So just work with your consultant and your owner team to sort of right size that invoice package. Only include stuff that people are actually going to look at and actually going to use. Like, every monthly invoice doesn't need to be a binder, thick, audit-worthy document. And consider using draft invoices in advance. It's a great way to, I guess, get consensus amongst the project team on what sort of supporting document are necessary, and even the valuation of the invoice itself before we're in a point where we're debating it later and now it's delaying payment.
Okay. I'll put Rick on the spot there. In your world of being a subcontractor, what kind of tips or processes do you take internally to make sure that you're submitting the correct invoice so that there's not any holdups?
Well, I like your last bullet point. Is a draft invoice required? And I would say yes. As your own trade contractor, create your own draft invoice checklist. It allows a couple of things. One, you're going to be talking a week early before that month is ending, so your foreman on site or lead installer knows what's going on. They can give you a projection of what will be finished. Because we need to remember that at the very beginning, this is done by an estimator at the general contractors, and then it's moved over to a project manager and project coordinator who may not talk back to that estimator anymore. So they need to understand the flow of what's happening on the project, and over time, they'll understand, and it makes it a lot easier having a draft as they share on site. It gets the team thinking, where will I be by month's end? I always say it helps with productivity, but it also helps the general contractor understanding with the site superintendents what's going on. So it not only does it help in the front office, it also helps on site. So I like draft invoices. It works very well in the P3 world, especially where there's payment certifiers, and we're seeing many more payment certifiers.
Katie, we'll talk a little bit more in a few minutes about this question in the context of those provinces that have prompt payment, because it very much affects what a compliant invoice looks like. But I think here the important thing is, as Trevor said, is to see what your contract says about what has to be submitted. And it could be far more than a single piece of paper saying, this month you owe me this much money. There'd be a lot of backups, revised schedules and updates and projections and all of the stuff that we've talked about here. And if you don't have those things, it gives the payment certifier or the owner or the consultant the opportunity to reject it all, and you start over again. And nobody wants that. The goal here is to get payment moving quickly. And as Rick said, whatever you can do to kind of pull that together, get it drafted, ready to go, meeting all the criteria, all the requirements, the sooner you can do that, the better.
And that's a good point, Glenn. If we send our draft invoice early, they're going to get back to us right away of what pieces of paper are missing in this process. So it also buys you time. It buys you generally a draft invoice is going in about the 24th or 25th of the month. That buys you 5 or 6 days to get the rest of that documentation ready that perhaps the GC needs to provide to the owner or client. So good point.
Yeah, and maybe just for the smaller quote unquote firms who are doing, again, quote unquote smaller projects, maybe that don't have multi-year timelines or anything, but maybe this is something that's subject to any of your contract terms. Maybe you do this for the first invoice. Set the stage, get used to what your project team, what the consultant payment certifier is looking for. So you may not have to do this every single invoice. But I think maybe to set the stage so that there's a common understanding. I think it's a really great point. So Glenn, handing it over here to you about everyone's favorite topic in construction, changes, and how changes, as we call it here, letting them slide. So what kind of process or should folks be instituting, and what are the challenges that are now happening?
It is true. This is such, at least in terms of payment, it is without question the main area of concern on a project is not getting paid the monthly payments that progress payments. That typically is less of a problem. There might be some disagreement on how much progress actually happened on the project, but it's really the changes in the work. And I think the best way to start is to underscore that the contract typically provides, and I say that because in terms of CCDC contracts, but if anything, supplementary conditions that we all see get added make it even more clear, not less, that you should not, as a contractor, be proceeding with work without either a change order agreed upon, or if no change order, at least a CD or change directive, as it's called. That's what the rule is. And yet, how often, if you were to ask, do a survey, how often does work progress without either of those? The answer is probably going to be 90% of the time or something like that. It's going to be a very high percentage.
Yeah.
And the reason is there's a whole process to arrive at a change order that's involved. Often, if it's a larger owner, public institution, for example, there's all this approval internally that's required, and changes in budget, and amending the contract price, agreeing often on time. And we've had already a session on time where we talked a bit about changes there. But even the relevant time extension associated with a change has to be sorted out. So there's all this work to get a change order. In the meantime, the project needs to move forward and needs the work to be performed. So often it's an email, it comes back to an email, go ahead and do it and we'll figure it out later, as the bullet point says, we'll figure it out at the end. So I think the important thing, as I said at the beginning, is to appreciate it's not what the contract calls for, and proceeding with that work without a change or a change directive or anything other than a loose email saying, go ahead and we'll figure it out, is a very risky thing to do. Because then you're just punting down the problem much farther down the field and hoping it'll all work out. And getting full value for that change order work later becomes much more difficult when that change order is then is just one of 150 similar change orders that have been punted down the field, and you've got a big binder of unresolved change orders at the end. You're not going to get full value for that. So what do you do about that? Well, at a minimum, there's a few things that certainly I've seen contractors and subcontractors do. Is first of all, to recognize that it is a change, go on record that you consider this to be a change, and while you're getting your pricing together, it's going to proceed on that basis. So if you're concerned that there's an argument that the owner is going to say this is within your scope of work, get that clear as at the beginning. Make sure that this is a request for a change, not a request to do something and you think it's a change, so you'll later put change order stuff together. Speak up, I guess is what I'm saying, is make sure that you go on record that it's a change. And so
Glenn,
that smokes out any dispute about it. Yep, Katie?
So when you say you kind of go on the record, does that just mean an email, maybe meeting minutes, or are you talking about, depending on the contract language, giving formal notice?
I think what would happen is if you got a request and normally some contracts provide that if you're being asked to do something that you think is a change, say so. And look to the contract as to what that is. If it's silent, then certainly at a minimum, an email would be okay to say, you're asking me to do something I consider a change, please issue a change order. That's all I'm saying. And if they say, what do you mean change? No, it's within the scope. Well, then you can go down that route, and I'll come back to what that means. But at least if it's a change, you say, oh, proceed and change, but I'm asking for a change directive at a minimum, and make sure you get the piece of paper to the extent you can extract it from the owner. The second thing, though, is that if they're saying, and by they, I mean the consultant under the contract, is directing you to do the work, it may be that, and they're taking the position that it's not a change and you believe it is a change, then that becomes a dispute. And that's an important thing just to emphasize. You have to look at the dispute provisions of the contract, because if a consultant directs you to do work which you don't believe you should do without extra compensation, that kind of dispute you have to object to within a certain period of time under the contract. All contracts, both the standard form and other forms of contract, give you a limited period of time to say, I don't agree with what you're saying. I don't agree that this is just within scope work. It is change order work, and I'm entitled to the change. So it's important that you not only speak up, but get, in a sense, a position that you can then dispute within a limited period of time, and make sure you dispute it. And in effect, you'll be directed to do the work under protest, as the scenario bullet point says, but at least you're preserving your rights. If you don't respond within time, the CCDC contract says you waive any entitlement to claim extra money if you don't speak up in time. So be mindful of that. So it's hard perhaps to make the connection between what we're talking about in terms of change orders and doing that work and disputes, but the two are very, very linked. Because often what's happening about change orders is not resolving the amount necessarily, but also whether it's in or outside of scope. And that's an important point. Now, as far as the amount goes, I think it is very important to track the material cost, the labor, the hours being used, and so on, and present that to the owner, even while you're working on what a change order might look like at the end. So there's no mystery about what this is actually costing anybody. I think that's important. To simply go away, do all the work, incur all the costs, and then be left saying, here's what it cost, is again risky. But if you stay in the owner's face, I can put it that way, about what this change is costing along the way, then it's going to be hard for them to say, well, we never agreed to that. Well, you never spoke up and said you didn't agree when I was telling you all the way along what this is costing. So that's another suggestion I've seen be successful. And then I turn it over to Rick and Trevor if they want to add anything to this.
I'll just add your dovetail off what you last said, the use of daily extra worksheets, either between the general and the consultant or subcontractor to general. That's a great way to make sure to track and stay on top of, and everyone's mindful of the tally as the work progresses as a best practice. And I want to add your comment around having a change directive in place, just to be mindful of the fact that contractors can be paid for work in progress on a change directive if the work is spanning more than a month. But it does wreak havoc on most accounting systems on getting paid on a change directive before that formal change order is in place. Most accounting softwares don't like to pay on schedule of value line items that doesn't have a change order attached to it. So work with the owner's side as well and figure out that process that will allow payment on change directives that are larger value, are going to last a longer period. If you're blocking off a placeholder change order or a dummy change order, or there's usually an accounting workaround for it. But if you don't plan for it, it can wreak some havoc for sure.
And I just add to that, coming back to the first point I was making, that if you don't have that, even some kind of mechanism, change directive, and preferably a change order in place, as you said, Trevor, understand you're not going to get paid by the owner because they don't have a mechanism. An email says, go ahead and do it and we'll figure it out. It means you're going to bear that cost of that work until they figure it out. So it's far better to come and say, well, what are you going to give me so that I can get paid for this work while it's taking place, rather than waiting till the end of the job and you financed as the contractor or subcontractor the cost of that entire change. Try to sit down and figure out what the paperwork is, the minimal paperwork at least, that can be put in place so you can bill on account of it as it's happening, if it's a big item. I think that's important.
I have one thing to add with that, Glenn. With the installers on site for the trade contractors, have an acknowledgement on a piece of paper. It's an extra to the contract based on our opinion, or it's an addition to the contract. And we are seeing more and more stamps. We are acknowledging that the work was done. We will not commit to payment. But we've already started the tracking, in my opinion, once that's done. So the fact that they put that stamp on there is acknowledging that there has been change. Now it's for the front, that documentation will now leave the site, come to the front office, and that gets the conversation going. So don't let them slide, as the changes here, letting them slide. I'm going to say, don't let them slide, as if we're learning anything on this one, number one. Okay. Note it if it's on a daily piece, send it in daily, give them a package every Friday, works well. You'll see if they're going to pay or not in a very short period of time.
So I wanted to, it's very easy, I would say, for us to sit here and talk about, pushing back on your GC, pushing back on the consultant and the owner, and but this is a relationship-based business. And one of the things I hear a lot is, I don't want to ruffle any feathers. I don't want to push back. I'm trying to maintain this relationship. So I'll throw it out to actually all three of you. Is that a legitimate concern? Should people put, I guess, the relationship ahead of maybe their business, their profitability? Just any comments on how, should people approach these sorts of conversations maybe without being so worried about the relationship in the background? Trevor, you talked about the honeymoon period earlier as well.
Yeah, I'll say that it's not personal. It's just business. Most people prefer having the frank, upfront conversation. And if you're worried about possibly ruffling feathers or straining the relationship, from my experience, it's 10 times worse leaving it unsaid and waiting till the end. And then the relationship gets much, much further damaged fighting about it later than having an upfront, honest conversation early on.
Yeah.
And I would
That's
just
a
add,
really great
Katie,
point.
I would add that actually I saw a client do this recently, effectively. Really, it's a bargain here. I'm happy to do your work. I want to support and our relationship and what you want to achieve here, and I will do the work, but I can't do it without paying the people, paying for the materials, and that's your side of the bargain as an owner, let's say, or as the general. You have to pay me, because if you don't pay me, I'm going to go out of business financing your project. So the bargain is just that. You pay me and I'll do your work. If you can't pay me or aren't paying me, I can't do your work. So it really is, you're putting it back on the owner to decide. But that's got nothing to do with the we have a great relationship, but it can't be one-sided. And that's really what I'm saying.
Right. Now
You're learning to
I'm gonna
develop a relationship.
carry on.
Yep.
You're learning to develop a relationship with a general contractor very early on. So when the difficult conversations arise, you can actually have a business to business conversation. There's business and there's friendship. And I know that there's a number of times where I totally disagree that I'm not going to get that change order, but that shouldn't affect my friendship. So I think we don't always separate those two, and it was brought up earlier. You need to get paid for the work that's being done. If it is an extra, you need to be able to justify that as well. But the difficult conversations, you will have started, you sat down at your negotiations when you're reviewing the contract, you can bring it up. How are we going to deal with this? Start early. Yeah. When everybody's still in that honeymoon phase.
And just on that, Katie, before we move to the next topic, I was just going to say, building on what Rick says, and I've seen this many times in my role as a lawyer after the fact, when a client says, but look at all the extra I did when they're not paid. Look at all the extra mile I went, trying to further that relationship. Well, the owner, of course, took all that extra value essentially for granted. There was no goodwill generated from it after the fact that led to payment. So don't think that being a hero and doing all this stuff and keeping your mouth shut and adding it is going to itself get you paid that extra money. You've got to tackle it as it goes, for sure.
Yeah, and I think we've gone down a different path. Maybe we do a whole other webinar series on relationship management and construction. But I think you can read your contract all you want, but if you're not going to follow the provisions in there and the guide and path that it sets out, you need to take that step as well. So Glenn, talking about prompt payment legislation, we did have somebody raise it in the Q&A as well. The purpose of this is not to go down this path of prompt payment, but just lay it out about how that impacts payment now in the jurisdictions where it exists.
Sure, thanks, Katie. And we're going to put up a slide next that shows the status across Canada in the various provinces of prompt payment legislation, who has it and who doesn't. Oh, there it is right there. You'll see it's quite a range. Some provinces like Ontario have had it for some time, or Saskatchewan is a little more recent. Other provinces, it's a work in progress. It's at various stages of the bill being introduced, or is going through a certain reading, or was passed but is not yet enforced in the case of the federal government. But there is a consistent theme to those jurisdictions that have prompt payment, which maybe we can go back and just talk about. And this, as you said, Katie, came up in one of the questions, is an understanding that when we talk about reading your contract and what it says, at the same time, you have to be familiar with, you have to read the legislation and what it says. And often there's a disconnect, or at least there could be a disconnect. Now, CCDC has recognized that there's provincial legislation in place for prompt payment and refers to it in the CCDC contract. You shall pay within a period of time, 28 days, or whatever your payment legislation says, if it exists. So it's kind of in referring to payment legislation in the contract by sort of alluding to payment legislation in the contract itself. But it is important, as was pointed out in the question, to appreciate that whatever the contract says, it's going to be affected by that legislation in the way that it can't be typically overridden in the contract. The legislation says, in the case, for example, of Ontario, that owners have to pay within 28 days. So as a contractor, if you open up your contract and the owner's saying, I will pay you your invoice within 60 days, the law rewrites effectively that contract down to 28 days. Ontario statute specifically says that any contract that contractual provision that is in conflict with the act is deemed to be amended to align with the act, basically. So be careful about those, being aware of what's don't accept, I guess is the best way to look at it, that because the contract says 60 days, I guess that's what I'm stuck with, regardless what the statute may call for. It's actually the opposite. And that's the key point. Now, in terms of invoicing requirements, Trevor talked about, reading your contract. When you have prompt payment legislation, you have to read the statute about proper invoicing too, because it spells out what a proper invoice is, because it's the submission of a proper invoice that triggers the timing. So look for what those requirements are. And I was talking to a group the other day about the fact that in Ontario, one of the things in the statute is including in your invoice the name of the person and his or her title and phone number and address to whom you send a payment. So on the invoice, it should say margin accounting. And here's the name of the person, and she's the accounts payable clerk, or accounts receivable in that case. You have to put that on your invoice. Now, most people don't know that, but it's right there not in a regulation, in the statute itself. So be very mindful of what the various statutes require in terms of invoicing to make your invoice a proper invoice, because that's what triggers, as I say, the payment obligation on the part of the owner. The last thing on that, and then we'll move on from prompt payment legislation, is to understand that the invoice I'm talking about is the invoice between the contractor and the owner, not between Rick and Trevor. You, Rick, have to submit your invoice, but that's not the proper invoice. Trevor takes what you and other subcontractors bill, put it together in an invoice to the owner, and that's the proper invoice that triggers prompt payment legislation, just so we're clear on that.
Thank you. And I have this up on the screen again. This is the status of prompt payment legislation across Canada. We'll be providing these slides. So anybody who's probably, not in the majority of provinces that have this, you'll be able to refer back to this. And I would say contact both your local construction association and your elected representatives if you are interested in wanting to bring prompt payment legislation to your jurisdiction. So, Rick, over to you and the subcontractor payment terms, and especially, and we've talked about it now, I think through every webinar and today about those flow down provisions. So, what are you looking for, and how do you mitigate, maybe any of those clauses coming down to you?
Well, again, I continue to read. We have a checklist for the prime contract. On the slide, that what to look for in the contract. One of the ones I like to go to is clause 8.2. I want to look at the negotiation, mediation, and arbitration. I want to review that for my understanding. Now, I have to thank Chris Moore for his patience and teachings on that over the years. I'm not a lawyer, but he's told me what, when, and who to talk to with regards to that. So that will really play a big role on mediation and arbitration. I mean, because of these flow down provisions from the prime contract, we'll take liquidated damages. what are your trade contractor deductibles? You know, you can ask your professional advisor, you can send that off and they'll tell you, perhaps I'm getting caught in liquidated damages that are including the electrical and the mechanical contractors. I don't want to be part of that. So how do I separate myself from that? So on the payment terms, that is something that can be done early on. I mean, force majeure, we heard part of that during, or that being discussed, and for some people that was part of COVID on the contract, you know, is requesting more time to complete. It's just an extension. It doesn't mean it's equating to more money, although I think some people were hoping they were going to make a lot of money off of this. So you have to understand what are the provisions you're going to be dealt with. Some projects, the payment certifiers was brought up. You know, we talked about draft invoices. Is the invoice for labor and materials? If you have a dispute with a payment certifier, you can actually write a letter and they must answer in a reasonable time. I mean, that's something I learned from you, Katie, way back is, you know, the payment certifiers also need to reply on why they're not agreeing with some of these payment terms. That maybe we're lacking documentation to the general contractor, and this is just information that's being pushed over to the trade contractor from the general contractor. Timing. Continue to put it in writing on your payment terms, email, print. You know, I'm even old school in the fact that I'll send an email and then I'll print that email and I'll put it in an envelope and I will address it to someone so they have received it in writing. I'm not going to go and type another letter, but I want to copy and mail that too if necessary. It's just evidence mail, and to say that we didn't receive it in writing, well, you've now received it in the post. So we make sure timing through email and timing through snail mail is working on that. And I think we'll talk about liens a little later in this, but I just can't reiterate enough. Checklist for your prime contract, what is really important to you, and check out the negotiation, mediation, and arbitration as a trade contractor. If these are projects that are lasting years, this can be years before you're going to get paid. It can be a real problem. So I'll leave that at this higher level here.
Katie, if I can just jump in to say, as Rick was saying, from a subcontractor's level, these categories, we've touched on some of these in other seminars, but it's what you have to understand is being laid at your feet. But particularly the last one is a concept, I'll just take a second to mention, equivalent project relief. That's the idea that you get, subcontractor, what I, the general contractor, get from the owner. So if I get 10 cents on my claim, you get your share of 10 cents and that's it. That's a clause you're going to want to pay attention to and understand that. Be careful when you're asked to do a change, that if it's a change that comes from the owner, you may not get full value paid for that change if the owner chooses not to pay it to the general. So you've got to be aware of these clauses, same with LDs and so on, because they affect what you get paid. If there's deductions, if there's set-offs, withholdings, see what the contract and both the prime contractor and your subcontractor says of the ability of people to pay less than 100% of your invoice because of some reason, some cutback. And these are some of the significant categories that you may be held accountable for, liquidated damages, for example, that you need to know going in what those are.
And I would say on the equivalent project relief, we tend to see those more in the P3 contracts than we will in any of the other project delivery methods. So good.
But what you will see, we didn't touch on it yet, and mindful of the time, you will see clauses that may bump up against prompt payment legislation, but clauses that obviously routinely say you will get paid if and perhaps, or when and perhaps if and only if I get paid from the owner. So if I don't get the money from the owner, you're not going to get the money either. And that puts the risk of non-payment on the subcontractor. Now, prompt payment has been introduced to mitigate that somewhat, but at least it remains a significant clause to pay attention to. In provinces, Katie, like BC, for example, that doesn't have any legislation. Be aware of those clauses too.
So we've now gone through, we've talked about, what people should be looking for as they're reading their contract, kind of the pitfalls of change orders, submitting a proper invoice, compliant invoice. Okay, but you've done all of that and now you're not getting paid. So I'll hand it over to you, Rick. In your role as a subcontractor, what do you do when you're not, getting paid? You're not getting your money.
Well, I like number one there, pick up the phone and call. I mean, again, it goes back to how to have difficult conversations that don't go sideways, hard on the issue, not on the person. And it's easier to defer talking company to company rather than individual to individual. I think a lot of people, I shouldn't say a lot of people, very too general up there. Some individuals will take this very personally and they think someone is coming at them. That's generally not the case. Somebody is maybe young to the contract, hasn't done it, doesn't understand negotiations or the contract. And again, you just need to be able to speak with them. So on the payment side of things, I think there's easier questions to ask. When is it triggered? When you're not getting paid? Have I missed something in the contract? Is it funding? I mean, we talked about deposit required on materials, securing labor, and a sub-trade contractor. We may have to pay them ahead of even being paid by our general contractor and the client. So picking up the phone, get off email. If you can do a face-to-face, I find face-to-face is the best thing going on these. Yeah, I mean, there's many factors here. Understanding progress or percentage complete. Glenn talked about that earlier. Time and material milestone payments, that's not always understood. And so that's why perhaps you're not getting paid. What is the frequency of payment? I think as trade contractors, even myself, I got to refer to my checklist and ask those questions in every meeting. They change all the time. So yeah, I mean, even asking for phased releases on projects that are going over a year. And another thing I've learned over time. But I have other larger trade contractors, the electrical world, the mechanical world. What do you do when you're dealing with this? And, sharing information among trade contractors is a good thing. You got to talk to each other. I think that also helps on site. That can play a big role. If the rebar trade contractor was having a tough time early on, maybe ask them why, right? I may not get on site after the concrete and trade till 9, 12, 15 months later. Follow the progress, jump in on your meetings early, meaning follow what's going on in these monthly meetings or bi-weekly meetings. You will get a much better understanding of the project flow. So not getting paid, there's reasons. Track the history of what's going on in that project as well. And then you can do it company to company. So I always like to look for timing and conditions for payment. I'm reiterating that. That's a big one. That's part of my checklist. What are my timing and conditions? Solving the issues together.
Great, Rick.
Yeah, solving the issues together. You have to find that mutual solution. Not always easy, and it may take more than one meeting. Most of the time, it takes more than one meeting. You've got 3 or 4 meetings to get through this. So.
Yeah, and again, it's not personal; it's business. And like you commented on, it's business to business. Is the approach to take. So, Trevor, kind of our part 2 of you're not getting paid now what advice is relates to both where there is prompt payment legislation and without. And so, what are some of those options available to folks to help them get paid?
Yeah, so when you try the soft skilled approach, like Rick mentioned, it didn't work. Just to run through a few of the contractual options you might have, and I'll mention 4 of them in no particular order. One is to read the section of your contract around contractor's right to suspend or terminate the contract. Mm-hmm. Usually there's language in there around if you're not being paid, you need to send a notice in writing of default if the consultant's not certifying your invoice in time or the owner's not paying you in time. There's typically a remedy period, some CCDC standards 5 days to remedy the default. Otherwise, you have the right to suspend the work or even terminate the contract. So start there. CCDC standard language also has the right to charge interest on overdue invoices. to the tune of prime plus 2% within the first 60 days or prime plus 4% after 60 days. This clause is often, I would say, superseded in supplementary conditions, but it isn't always. And it's definitely not easy to get paid interest on overdue invoices. That rarely happens, but sometimes just the threat of sending one can be the motivation people need to get this situation unclogged. Registering a lien is sometimes an option if you're still within the available lien period, which in Alberta has recently changed from 45 to 60 days with our prompt payment legislation. But I'll disclaimer, this can sometimes be counterproductive, and to have the conversation first with your general or upstream owner, because sometimes owners will automatically halt all payments once a lien has been filed. And then the contractor's in a situation, well, like, I can't pay you now or anyone else until this lien is removed, which further delays payment. So have the conversation first. There's sometimes other options available. And lastly, there may be performance security or options to recover payment, either in the form of labor material payment bond or subcontractor default insurance. So get a copy of those certificates, read the instructions carefully on how to make a claim, because they can sometimes be very complicated. So you need to be very diligent in how to administer those or request professional help if necessary. So those are 4 options contractually to pursue to help accelerate payments. And then the second bullet there, if you're in a jurisdiction with prompt payment legislation, basically all the above options still apply, with the addition of having an adjudication process, which is, to not go into too detail, it's basically just having a certified adjudicator appointed to deal with your dispute and make a resolution process and make a judgment specifically around your payment situation.
And on that, Katie, the adjudicator can have the power to address both non-payment, in the sense, the monthly payments or whatever is not being made, but also determining the amount of a disputed change order. And if the change order amount is found, then that determination by the adjudicator becomes a part of the contract price and is payable. And in Ontario, it's payable within 10 days of that determination. So that's another way to get paid a disputed amount of a change order, is to have an adjudicator decide the amount, and then the general contractor, the owner, has to pay it very quickly. Otherwise, you can stop working. So the adjudication certainly enhances everything else Trevor went through.
And we've already worked through our whole hour. And so I just want to kind of summarize some of these takeaways, and just takeaways from our the entire 5 webinar series. Don't be afraid to enforce your rights, both statutory and in that contract that you've read in the prime contract, in order to get paid. And also, it's not personal, it's business. And talk to an expert. That expert, could be legal counsel, could be your broker, insurance and bonding broker, could be just somebody more senior in the company, or somebody else, that is an expert. And we cannot underline this enough, but read your contract. Take the time. If you're a sub and there's flow down provisions, get your hands on that prime contract. You may be fine. You might have been fine every other project. This could be the one. So make sure you're reading your contract every time. So we are out of time for questions, but reach out to any of us, Kenny at CCA, somebody at your local construction association, and we can help answer any questions. And again, thank you so much for joining us on this webinar series. They're all going to be posted online for you and other folks at your companies to be able to view. So thank you so much. Thank you to our panelists. And we'll see you at the next CCA webinar. Thank you.
Thanks, everyone.
Thanks. Bye-bye.